Hello, this is Paul Callaghan from Taylor Wessing, and thank you very much for joining our webinar on Brexit Next Steps for Businesses. So, last Thursday, the UK surprised both itself and the rest of the world by voting by a small majority in an advisory referendum to leave the EU. What that means from a legal perspective is it is not entirely clear. It doesn't automatically mean that we leave the EU, and my colleague Sian Skelton is shortly going to take you through the various different options as to what might happen next. For the purpose of this webinar is primarily to let you know from a business perspective what you should be thinking about at this time, what immediate consequences there may be, and what planning you should be doing for the future, if any, covering a whole range of different legal areas that you need to be aware of if you're doing business in the UK. There's no precedent for an exit from the EU. We're the first country to be potentially leaving the EU, and until we actually give notice formally to leave, we remain a member, and that notice period is 2 years from when we actually give notice. So nothing is going to change immediately. You can see on that slide some of the potential options that we may be considering and trying to negotiate with the EU as the UK looks to leave, and Sian will take you through what they mean in a bit more detail. From a day-to-day perspective, views are changing as to what it is that the UK is likely to look to do, but it may well be that we do come to some sort of deal whereby freedom of movement remains on the table, although there are political pressures in relation to changing that. And also, what our referendum has done is created some pressures in other EU countries to have similar referendums, including in France and the Netherlands, but thus far they are both resisting. So in the meantime, I will hand over to Sian, who will talk through some of the more obvious options for exit.
Thank you, Paul. While there are uncertainties around the form of Brexit and the length of time it will take to conclude, there are a number of existing models for relationships between EU and non-EU countries which might form the basis of the UK's continuing relationship with the EU post-exit. I'm just going to touch on these at a high level now. So the first one to consider is the Norway option. And Norway joined the European Free Trade Association, the EFTA, and then also joined the European Economic Area. By doing so, this allows Norway to participate in the single market, but also requires them to adopt a number of European legislation and laws and to operate within this structure. The next option would be the Swiss option. Switzerland became a member of the EFTA, and then rather than joining the EEA, has negotiated a number of bilateral agreements within the EU which allows them to trade. There has been some political pushback against this option from the European Union already, so it's unlikely that the Swiss option would be available to the UK, even if they wanted to try and push for this approach. The next option that could be considered is the Canadian option. Obviously, Canada is a country that's very remote from the EU, but what they have done is they have been negotiating over a period of the last 10 years a number of free trade agreements with the European Union. Now, as I said, the negotiations have been ongoing, and although nearing an end, they have been ongoing for a period of over 10 years. So, again, this could be a lengthy approach. Then there's the rest of the world option. This is the option where the UK would not be subject to any EU law and would not have to make any contribution to the EU budget, but would be subject to trade tariffs and have to comply in respect of certain EU standards in order to be able to trade with the EU. So again, it's not really certain as to whether this would be appropriate for the UK. And then just to round off the other options is Flexit. This is the preferred choice by many of those who are in the Leave campaign. This favours taking the Norwegian option in the first instance, and then continuing to evolve the exit through ongoing negotiations over a period of several years. They those that favour this option believe that this will give us the greatest flexibility and movement. But of course, that is all subject to agreement with the European Union itself. So, what would be the likely legal effect? Obviously, we're going to go on and talk about the different specifics that will affect the different businesses and different areas, but it's probably unlikely that upon exit, should we actually get to that stage, that the government would remove all EU-derived law. To do so would be a huge logistical undertaking, and getting consensus in the government on what it should be replaced by would be very time-consuming. From a trading perspective, many areas, if we do not comply with EU law, we will not be able to trade with the EU. So we will have, in certain circumstances, no choice but to comply and adopt certain EU laws and standards. Areas of laws which we think are unlikely to change significantly would include consumer protection, product liability, and data protection. Obviously, if the UK does exit the EU, and depending on which model and structure is implemented at the time of exit, we may not be required to adopt all or any new legislation which comes out of the EU. But again, for consistency and for our ability to trade, that's something that is in question, and the likelihood is that we would have to at least adopt some certain standards to be able to continue to trade. So that's a very high-level view of the different options that will be open to the UK. I know we're going to dive into a bit more detail looking at specific areas. I'm going to hand over to my colleague Charlie, who's going to be talking about immigration in the first instance.
Thank you, Sian. Hello, everybody. So immigration was a key battleground in the Brexit debate and was one of the main factors leading the UK to leave the UK. To leave the EU. The perception was that immigration levels to the UK are too high. Let's look at some of the scene and the background to that. So free movement of workers is one of the four key pillars of the European Union. It means that workers in any of the EEA countries or Switzerland can come to the UK to live and work. There's no restriction on the type of work that workers can do, and indeed no restriction on the numbers of people that are allowed to come to the UK. EU workers do not require any visa or authorization to be able to work. And that flexibility has led to a record level of net migration to the UK, currently standing at about 330,000 people each year. Around half of that is EU migration, and the rest is migration from the rest of the world. And there's several million people across the UK and across Europe that are affected by the Brexit decision, as we'll look in a bit more detail as to how that might play out. So I think the key message for an EU workforce is one of reassurance. It's business as usual for the time being. During the exit negotiations over the next at least 2 years, or we think 2 years, it's going to be the UK remaining as a full member of the EU. That means that freedom of movement of people will continue. So what does that mean in practice? Well, existing EU workers already in the UK can continue to work. There's no problem there. UK employers can still continue to hire from overseas. Any EU citizens, they can continue to arrive in the UK and work without restriction, without a visa. British citizens who are currently working in other EU countries as well can still continue to work during the exit period. And in all cases, the status quo is preserved, so no visas, no authorization permissions are needed. And the visa rules for non-Europeans are completely unaffected by Brexit. They continue as normal. So, during the exit negotiations, there will be discussions about the exit arrangements for the UK, and part of the key things on the table here will be what happens to EU citizens and British citizens as a result of exit. What are the rights of EU citizens and their family members to remain in the UK? What are the rights of British citizens who are working across Europe to stay in that country? And those rules are likely to be reciprocal, so will mirror the UK position. We'll need to look at what permission is granted to those people who are currently in the UK and working Will it be a temporary permission? Will it be a permanent position? There will be, no doubt, eligibility for those people to preserve their status through a mechanism of applying for some form of status that will apply from the exit date. What will need to be determined are the precise conditions for the cut-off for eligibility. So will it be EU citizens that are in the UK on the departure date, for example? I think the general consensus among practitioners and lawyers and even the campaigners for leave is that any EU citizens currently working in the UK, living in the UK, should not be affected by Brexit. The trade negotiations will be conducted separately to the exit negotiations, and of course the outcome of those may well determine the position for EU citizens. If there is free movement or something close to it, then of course the position will stay unchanged for those people already here. So what about the position for immigration after the exit from the EU? And this is the key question that is linked to the trade negotiations, and what many people are asking is, well, what is the price for access to the single market? Most campaigners on the Leave side are looking at getting access to the single market, although that position is changing daily. But European leaders are keen to ensure that if the single market is achieved, that free movement is the sort of trade-off for that. Politically, we feel it's unlikely that the UK electorate will accept free movement in its current form, and there will need to be some restrictions or modifications to it to make it acceptable to voters. So what are those options? And to follow on from what Sian was saying around the different models available, there's the Norway and the Switzerland model. They both have accepted free movement, unrestricted free movement, and so to take their model in its current form is unlikely to work, but perhaps that model with some limited controls on free movement of workers. One suggestion has been perhaps it could be free movement of workers that have a job offer, so to exclude those people that are coming to seek work who don't have a firm job offer, and under current statistics that would be about 77,000 people in the last 12 months under the latest numbers. Other Leave campaigners are looking for an Australian-style points-based system which assesses people's ability to come to the UK on their attributes and would mean effectively visas for workers, probably not for travellers, but would mean more red tape, more lead-in time for recruitment, and a greater compliance obligation on employers. Whatever happens in relation to those new rules for EU citizens coming to the UK, we expect reciprocal controls to be placed on British citizens wanting to go and work in the rest of Europe. So, just to finish up, what do we think that business should be doing next? What's the strategy? I think the first thing is reassurance to concerned European staff. There's been a lot of worry about the impact on Brexit, and as we've discussed, we don't see any changes in the immediate future, and some transitional arrangements to make sure people here can continue to stay. But there's also things that Europeans in the UK can do to safeguard their rights. So during the next 2.5 years of the exit negotiations, any European citizen that's been in the UK for at least 5 years can secure permanent residence as a worker, as a student, or as a financially self-sufficient person. The same is true for non-European family members of European workers, and also anyone who's got permanent residence in the UK can then use that as a stepping stone to getting a British citizenship and a British passport, which is the best way to ensure that there's no ambiguity about status at the end of the exit negotiations. Anyone who's been in the UK for less than 5 years can still register their status, so we feel it's best to get ahead of the game now, register status, because that may well be a requirement that comes out of the exit negotiations when there's going to be a big spike in application numbers. And again, going back to the position for British citizens wanting free movement rights, they also would be able to have equivalent registration rights for people working in Europe, but we're also seeing a lot of British citizens interested in getting dual citizenship with other European countries. The Irish Passport Office has been inundated with British citizens interested in Irish citizenship, and we feel that's going to continue. But to continue the workforce theme, let me hand back to Paul Callaghan to talk about the employment side.
So the flexible employment laws in the UK have for a long time been an attraction of the UK to businesses who are looking to set up in Europe. In reality, the UK has always had the most flexible employment laws within the EU, and that's unlikely to change. If anything, withdrawal from the EU is probably going to result in us having even more flexible employment laws. But as the earlier speakers have made clear, nothing is likely to change until we have actually left the EU, and there is a 2-year notice period, and we haven't even given that notice. There's also an awful lot of political pressure at the moment not to give notice unless and until we know what sort of deal we're going to have. So realistically, we may well be talking about 2.5, 3 years before, in fact, the UK does leave the EU. And to a certain degree, that means you don't know precisely what's going to happen. But from an employment law perspective, in a way, it's win-win, because while we remain in the EU, we're subject to EU employment laws, but we still have the most flexible within the EU. And if we leave the EU, then we would be free to potentially dilute some of those laws, and so our labour market would be even more flexible still. And on the slide you can see at the moment, you can see the areas that are covered by EU law. Now, if we do leave the EU, that doesn't mean that these laws are automatically repealed. In fact, each one of them stays exactly the same unless the UK Parliament then decides to either repeal them or to amend them. But as I say, part of the attraction of leaving the EU for those who've pursued that agenda is in order to increase flexibility. So I think I can probably safely say, certainly under the current government, that there will be no change to employment law which is going to be more onerous for business. So looking at changes that might happen, at the moment, compensation for a form of unlawful discrimination in the UK is uncapped. And that's because, following a case called Marshall, we've been required to have uncapped compensation for discrimination. Under the previous government, the previous government looked to introduce a cap. In the UK, we have a cap for unfair dismissal, which isn't an EU-derived right, and that's at 1 year's pay, or about £80,000, whichever is the lower. And there was talk about introducing a cap for compensation too. That hasn't been possible because of EU membership, so it's possible that if we do leave the EU ultimately, that some sort of discrimination cap will be introduced. I wouldn't expect wholesale massive changes in discrimination law. Sex, race and disability laws pre-existed the requirement from the EU to have those laws. We do have other protected classes that were effectively imposed on us by the EU for age, sexual orientation and religion or belief. But in reality, I think politically it's unlikely any government is going to want to repeal those. They've become accepted as cultural norms, and it's generally the general view is that it is appropriate for the law to prohibit discrimination on those particular grounds. TUPE, which is, for anyone who doesn't know, is the transfer of undertakings protection of employment regulations, is often been controversial. What it essentially means is that when you buy the assets of a business, you inherit the employees working within that business or the part of the business that you buy as if you were the employer all along. You get them on their existing terms and conditions, and you get any liabilities that go with them. So basically, they have continuity of employment when you buy that business. It also applies where there's a service change, so an outsourcing type of situation, where you have a collection of people carrying out a particular economic function, and that function's moved from one company to another. The contract of employees contract of employment of employees assigned to that area automatically transfers. Now, the government has been talking about abolishing that second tier for some time, and that second tier actually doesn't come from the EU at all. So theoretically, they could do that. A number of EU countries have transfer of undertakings provisions that don't include service provision changes. But in reality, when the government consulted business about changing those provisions a year or two ago, business didn't want those to go because they liked the certainty of knowing that when they entered into a contract for services, CHP would apply on entry and on exit. And business certainty is on the whole what we want. You want to know the price and the value of what you are getting and what you may be encumbered with. Now, it seems quite possible that if we withdraw from the EU, we could abolish CHP altogether, and that certainly can't be discounted. When it was initially introduced in 1981 by the then Conservative government, that Conservative government did so through gritted teeth. They didn't want it. But it's become more culturally accepted now. So I certainly think initially it probably won't be abolished completely, but it may well be that the service provision change element goes, not necessarily because they can, because as I say they can now, but just to show that they're doing something to reduce the regulatory burden. And I suspect that that's something they've thought about removing before. It's something that they might actually do in practice. So what that means for you and business, I think, is that you need to be thinking when you're entering into any contract for services now about ensuring that priced into the deal is the possibility that CHP will not exist at the time that deal comes to an end. At the moment and previously, those deals are negotiated on the basis that the employees are most likely to transfer to a new supplier if the contract comes to an end. They now need to be drafted with alternatives to deal with who's going to pick up the cost for redundancies and any other employee-related costs if in fact the law has changed by the time that contract comes to an end and CHP doesn't apply. Another area that has been a bête noire of those who don't like EU regulation is the Working Time Directive. Without the directive, there'd be no right in UK law at all for paid holiday. It would all simply be a matter of contract and what was agreed between the parties. As many people will know, as a result of the Working Time Directive, employees are entitled to at least 28 days holiday, including public holiday. Again, it seems unlikely politically that will be scrapped altogether. Although the Working Time Directive and the way paid holiday is calculated and the refusal to allow you to come to a separate arrangement with atypical workers as to how you calculate holiday pay is controversial. And so while I think it's unlikely for political reasons that the right to holiday will be scrapped altogether, I think it is quite possible that the rules will be simplified and that those who are casual workers or atypical in some sort of way will potentially be able to be treated differently. Likewise, the agency worker regulations. Those are relatively recent, and they were very unpopular with the government at the time that they were forced to introduce them. They essentially say that you need to treat agency workers the same as permanent employees. I think because they are fairly recent and they're still unpopular in the eyes of many of the politicians who are leading the Brexit campaign, it's likely that they probably would be scrapped if we do actually leave the EU, and if we go for a model that allows us to scrap them. The reality is, if we go for the Norway option or even the Swiss option, we will still have most of the EU-derived employment law. Under the Norway option, being a member of the EEA, virtually all of the employment law regulations still apply. Strangely enough, it's the Equal Treatment Directive that doesn't, which is the one covering discrimination laws. So we could still see a cap on discrimination compensation. But CHP is still there, and most of these other regulations that we've talked about would be required. Under the Swiss option, where it's bilateral treaties, of course you're negotiating the particular terms. So it may well be that as part of our deal, our bilateral deal, we agree to take on some directives and manage to negotiate out certain others. So that's an overview of employment. So very much look at any services agreements and think about CHP. Also, actually, if you are thinking of relocating some of your employees to another European Union country as a precautionary measure, and bear in mind that if you do transfer out an entire function, that would, as the law now stands and will, for at least 2 more years, constitute a TUPE transference, you'll need to comply with the TUPE laws, which will include potentially offering those employees a job in that other EU country. So now I hand back to Sian. He's going to talk about intellectual property rights.
Thanks, Paul. Okay, so I thought it would be useful just to briefly go over the possible impact on intellectual property rights for businesses as a result of our potential exit. Firstly, if we look at trademarks and registered designs. So in the UK, we are part of the EU trademark and registered design regime, and once registered, they have protection across the whole of the European Union. If the UK decides to leave and the exit goes ahead, then subject to any agreement otherwise, to preserve the protection of the trademarks and registered designs in those European countries, those holding a European trademark and registered design would potentially have to apply for those trademarks and registered designs again separately is with the UK registration body. Now, what's likely is that there will be an agreement between the European Union and the UK in respect to this registered IPR, and they will agree a formal protection. But again, this is something, especially for those with large trademark or registered design portfolios, to keep a watching brief on, because often people have chosen to go for a community trademark and registered design approach across all countries rather than registering individually in the UK or in individual European countries. And so again, as it becomes clearer what the position is going to be, it may be that for defensive reasons a registration locally in the UK may also be recommended. With respect to patents, currently patent law across the EU is not generally harmonised, and so an exit is probably not going to make a massive amount of difference to patents and the patent strategies that businesses are applying. But there is one area that may be affected, and again, this is all subject to it being, unless it's resolved prior to exit, and that's in respect of supplementary certificates. So supplementary protection certificates are available to extend the life of certain patents on certain types of limited types of inventions. These certificates are operated via an EU registration and regulation process, and therefore on our UK exit it's not automatic that they would continue to be available to UK companies and those with UK patents. So again, for those where it's relevant to their portfolio and their protection strategy, keeping an eye on the approach on exit with respect to registered patents is going to be critical, especially for those that need to rely on the supplementary protection certificate. With respect to copyright, actually again, so copyright law hasn't across the EU isn't harmonised. This is similar to patents, and to a great extent we don't expect any change to be taken or undertaken in respect of copyright upon an exit. There's just one flag to note, and that is there are a number of proposals currently being discussed in Europe at the moment around harmonising copyright law and the approach taken by each of the European countries in respect of that harmonisation. Now, should the EU push ahead with that harmonisation, that will obviously have an effect on the UK, and it will then be for the UK to decide whether they should also adopt that harmonised approach in respect of copyright, and presumably that will be looked at as part of the exit procedures. Those conversations are still at an early stage, and we still don't have great visibility as to what will happen next. We just wanted to turn now to consumer law. Obviously, the reasons that many businesses in the UK will look to extend their markets is to do so by selling into and across Europe. And obviously, even if we exit the European Union, the expectation is that businesses will still expect and want to continue to trade across Europe. In recent years, there have been a number of consumer law changes which have been initiated by Europe, resulting in some instances in a harmonised approach across Europe. So, for example, the consumer contract regulations in 2013 introduced the right to return goods bought online within 14 days of their delivery, and several other changes to the sales of consumer products online, and these have been adopted evenly and across the whole of Europe. Although the EU has harmonised some aspects of consumer protection, the UK has recently gone further and in 2005 adopted the Consumer Rights Act, which is predominantly a consolidation of existing consumer legislation, but it has introduced new rights for consumers, mainly in respect of digital content. Such rights are not currently available to consumers in many of the European countries as it stands today, and so as it stands, the UK is ahead of the curve in terms of offering rights and protections to consumers, and the European Union is flagging behind in this respect. One of the consultations that's happening in Europe at the moment is in respect of the digital single market, which is being currently undertaken. And if this goes ahead, they are looking specifically at making further amendments and regulations around consumer rights and consumer protections. If these regulations came into force after the UK has voted to leave and after we have exited, the UK consumer legislation authorities will have to decide whether they are going to adopt similar or the same legislation to allow UK businesses to be able to effectively trade with European consumers on a day-to-day basis. Finally, with respect to trading standards and product liability, the UK government have already stated that they won't make any changes in respect to these and will continue to apply any standards imposed by Europe, ensuring UK businesses again will be able to continue to trade. This is very high level with respect to consumer. We don't expect a massive amount of change, but again, where Europe is moving towards a harmonised approach and the UK has successfully exited, the UK will have a decision to make as to whether they also implement those which will allow their businesses to continue to trade. And now I'm going to hand over to Chris, who's going to talk about data protection.
Thanks, John. So data protection, like consumer law, is a heavily harmonised or theoretically harmonised body of EU rules, which governs, as many of you will know, the collection, use, sharing and security of personal data. And it's already a challenging area at this particular time, even before Brexit came on the horizon. Many businesses are preparing for the General Data Protection Regulation, which is a major upgrading of European data protection law with much scarier enforcement powers. And many businesses are struggling with the challenge of making transatlantic data flows compliant, whether it's a European business using a US-based software provider hosting data in the US, or a US provider trying to sell a platform to European customers. The death of safe harbor, the Schrems and Facebook controversy and so on are creating a major headache for many of our clients. And then Brexit comes along, and so what additional challenges does Brexit create? Well, some of the main questions that we've been seeing are whether UK businesses should continue to prepare for the General Data Protection Regulation. For data-rich businesses, that is a major undertaking. And because it's a European Union piece of legislation, if the UK does formally and definitively Brexit, then we won't be subject to it. Another question is whether businesses should continue to host and to process personal data on EU citizens generally within the UK. Just a few days ago, it was announced in the news that Visa Europe are looking at relocating to Germany because of the volumes of European-wide credit card information that they process. And I guess the last major question from Brexit is for non-UK businesses, particularly North American companies looking at the UK market, will the UK remain plugged into European data flows and at the same time be lighter touch than many continental countries? One of the attractions of the UK to technology companies coming in, for instance, is that the UK is part of Europe for data flows, but has a regulator which takes a more business-friendly and pragmatic approach. And so the question is, well, how long will that survive, and what does that mean for inward investment strategy in Europe? Well, the broad consensus, and I think we share this at TW, is that whatever Brexit looks like, the UK will work hard to align with the EU requirements on privacy. So we expect the government to implement the GDPR, or if we are not even part of the European Economic Area, something close to it, just to remain plugged into the transfer of data, because it's so much the lifeblood of the modern economy. And what that might look like is either we'll do what Norway have done and be part of the European Economic Area, which is the region for the free flows of data within Europe, or if it's not, if it's Switzerland or a Canada or a Korean option or whatever it might be, that the UK will be able to be designated an adequate country, just like Switzerland or Canada are, for the flows of personal data. The worst case, so that's quite optimistic, I think, in terms of privacy. The worst case, of course, because it does depend on the deal that is done, is that an EU deal is elusive, that the UK is not found to be adequate for data flows, and the UK ends up in a similar position to the US is at present, with all the challenges around model clauses and other compliance mechanisms. We don't think that's likely, but it is not impossible. And that has led to, if you think about the visa example, it has led some companies looking at European-wide business opportunities who need to make a decision now or in the near future about where they base their headquarters or where they set up data center capacity or technical support teams. They are looking perhaps a little more seriously at Ireland or the Netherlands or other continental countries than they might have done just a couple of weeks ago. And then I wanted to talk a little bit about what we're seeing a lot of businesses doing in terms of analysing the commercial impact of Brexit. This is really about looking at business units, products and revenue streams and analysing the potential, often negative impact of Brexit, as much from a financial and a business perspective as from a legal one. Some of the main issues that have come up in the work that we've been doing are, for instance, where a business unit is dependent on EU citizens working here in the UK, or UK citizens moving around Europe, and this is what Charlie was talking about, of course. A number of businesses have effectively a peripatetic EU workforce relying on the European rules on free movement. Also, if business activity levels are affected, could there be a reduction in demand? Sectors like advertising are often a bellwether for economic activity, and already they are seeing budgets being squeezed. If custom tariffs are introduced on goods being exported out of the UK, could that mean that margins are eaten into and therefore relationships become unprofitable? And so manufacturers are looking at that, but they're also looking down their entire supply chain to see whether the manufacturers of components that they use may find it challenging to continue to supply them. If goods or services are dependent on a clearance or permission under EU law, like the financial services passport that my colleague Jonathan Rogers will talk about later, currency fluctuations impacting margins, and people's ability to exit a contract if it's become unprofitable. All these things are part of the contingency planning that businesses that do trade between the UK and the rest of Europe need to be thinking about. Other things that are on clients' minds are analysing existing agreements. So we're very used to, as lawyers, drafting definitions of the European Union. It may be a permitted territory for a distributor to sell in or an agent. It may be a licensed territory for the exercise of IP rights. And the question becomes, if Brexit definitively happens, do those rights fall away because we're looking at a slightly shrunken definition of the European Union, or is it the EU as existed on signature? And then again, if economic fundamentals have changed, if currency fluctuations or custom tariffs make an existing arrangement unprofitable, can you use force majeure rights? if there's a definition of material adverse change, could Brexit and its economic implications come within that? And then last on commercial impact, looking at future agreements, agreements that are signed that will last more than 2 years out, where there's a UK and a continental European element, I think it's a good idea to address Brexit specifically. Whether you're the business that wants to future-proof the agreement so the other party cannot get out, whatever the implications for them of Brexit might be, or if on the other hand you want the flexibility either to renegotiate pricing or to terminate, it's going to be we're seeing increasingly people expressly stating that Brexit is not grounds for termination or is grounds for termination, and inserting those into force majeure or material adverse change contracts. And then, I guess, connected to commercial agreements, Andrew Howell is going to talk about commercial disputes and the impact of Brexit on that.
Thank you, Chris. Hello. Briefly to look at commercial agreements and managing the potential for disputes. So EU law is relevant to jurisdictions, so where a dispute is heard, the law which applies to the dispute, to service of legal proceedings, and to the enforcement of judgment. So I think we would suggest three key messages at this stage. The first is, in practical terms, we don't expect very much to change. These rules are harmonised across non-EU states as well. London is an attractive venue for determination of disputes. It's clearly an important part of the selling point for the economy, and we expect things and the government to want to keep that very much in place. The second, to the extent that there is any uncertainty, it will arise if parties do not provide for jurisdiction or governing law in their agreement. So the advice is familiar, that it's important to draft clear clauses in commercial agreements providing for jurisdiction and governing law clauses, which we would expect to be respected in the usual way under EU laws or indeed under the English common law. And the third is in relation to enforcement in particular. The enforcement of arbitration awards would be unaffected by any Brexit implications. As I say, we don't foresee significant changes in relation to court proceedings in any event, but this may be an advantage, I emphasise may be an advantage, amongst many other considerations in proposing arbitration rather than litigation. We don't suggest that that is a point which outweighs all others, but it is one perhaps to be considered in the way which it might not have been 10 days ago. So I'll now hand the baton over to Phil Shepherd, one of our corporate partners, to talk to the company law aspect.
Thank you, Andrew. Well, continuing the theme, there's no change in the short term here as well, of course. Company law, the practice of executing corporate deals in the UK is not going to change anytime soon. And actually, even looking forward to an eventual exit from the EU, we do not anticipate any material changes there. The English Companies Act, the Takeover Code, and so on, we don't anticipate anything really changing. European cross-border mergers may cease to be an option depending on the negotiations, but we expect everything else to look pretty similar in a few years' time with UK out of the EU. Lots of deals, international transactions, of course, are conducted under English law. That will, as well, we expect, continue. However, inevitably, the political uncertainty and the resulting impact on the economy will cause some people to pause as events unfold. And it'll be interesting to see how market confidence holds up in this new environment. Has uncertainty become the new normal? Businesses are going to have many issues to navigate, lots of different challenges, but also potentially lots of opportunities as well. For example, there's been a lot of talk about the weaker pound perhaps making UK companies more attractive for acquisitions for inbound investors. We may see more public company M&A with perhaps US investors coming in and looking at UK assets. And of course, some sectors, as the economy develops over the next few years, may do particularly well out of the changes. Some may be hit more. So all of that could lead to some increased M&A activity. We are gathering statistics for the M&A transactions that we're currently working across the TW family. And whilst it's too early to draw any firm conclusions, actually the majority of transactions are continuing as normal. Some paused immediately following the outcome of the vote last Friday, but actually even of those, a number of those have now resumed. What's more difficult to foresee is what the medium to longer term activity looks like. The next wave of deals that haven't really got underway yet, will they be affected or not? We wait and see. For M&A activity that is going to be proceeding in the coming months and years ahead, we do expect more of a focus on due diligence on all the sorts of things that the other speakers have been and will be talking about. So all of these other particular issues that Brexit will be throwing up. Looking at the IPO markets, we don't expect to see that much, I think it's fair to say, over the summer months this year, given the volatility in the markets and the usual summer slowdown in IPOs. We don't think we'll see much before September, but that said, we do currently expect to see some IPOs that are already lined up for September or October moving forward. Longer term, we again wait and see. Venture capital, there will no doubt be an impact on the sector. Funds may become more cautious as they look to invest. Some of the deals will inevitably be put on hold or will be pulled. But our view at this stage is that the underlying fundamentals behind the prolific venture capital activity we've seen in the UK market over recent years do remain the same. The tech sector is really mainstream now. There's a lot of capital there to be put to work. Indeed, at least one new fund has been announced this week in the UK, as well as a new one in the US, and probably more than that. There remains and will remain a lot of talent in the UK, notwithstanding all of the points Charlie was talking about regarding free movement of workers, which is of course a legitimate concern for many businesses. But the UK also has an increasing number of serial entrepreneurs. There's strong government backing for the tech and life sciences sector. We don't expect any of that to change. And again, in looking at the transactions we're working on, the vast majority of investments are continuing. Touching on private equity, a similar story there, I think. Funds have raised money. They need to put that money to work. Funds are agile, and actually value adjustments there could perhaps bring opportunities. There would, of course, be challenges as well, and again, it'll be very interesting to see how that develops over the next few months and beyond. We will continue to be monitoring events, but for now, the impact of the referendum result on corporate deals we're seeing is perhaps surprisingly limited. And with that, I'll hand over to my colleague Robert Vidal, who heads our EU Competition and Trade Group.
Thanks, Phil. Hello, everyone. In relation to competition law in the UK, you have little to be concerned with in the short term. So given the 2-year negotiation period when Article 50 is triggered, if triggered, and the fact that it looks like nothing will occur for a few months, the CMA have recently confirmed it is business as usual, and the referendum result will have no immediate effect on the competition rules. So I've listened carefully throughout the enthralling referendum campaigns, and as far as I know, none of the Brexiteers have explicitly mentioned changing or reforming the competition law rules. Competition law is probably not a priority, given that they will have plenty of other things to occupy themselves with over the next few years. Regardless of what is eventually negotiated by the UK, it is unlikely to result in a change of the substantive law or in terms of the level of enforcement. The Conservatives have, since Margaret Thatcher was in power, traditionally been absolutely committed to competition law, given it is one of the few areas where there is a general consensus amongst free market economists, such as Friedrich Hayek, that regulation of competition is fundamental for a free market economy to work effectively. There is no indication anyone intends to change the nature of the free market economy in the UK. Competition law will be applied in the UK whether we end up with an EFTA-type arrangement or if we exit entirely. The main difference will be that if we join EFTA, the EFTA Surveillance Authority will take over the role of the European Commission in terms of enforcement on a European-wide basis. And if we do exit the single market entirely, then the CMA will simply apply the rules on a national basis, while the European Commission will apply the rules if there is any spillover into the EU. The two areas that are likely to be most affected are mergers and investigations. So the likely result, if we leave, is that the one-stop shop that we currently have in place, the merger control, which determines whether the national regulator or the European Commission will have jurisdiction, will end. And companies will therefore need to notify a qualifying merger to both the CMA and the European Commission, effectively duplicating the work and the costs required. The same is true in terms of any competition law investigation, where the CMA and the European Commission could end up investigating the same infringement, where there is an effect both on the UK and in the EU. This will again duplicate the costs and the potential fines for an infringing party. In terms of the substantive law, it is unlikely to change in the short term, although over time, if the UK is no longer bound by the law of the European institutions, and this is one of the aspirations set out by the Brexiteers, we could end up with a gradual divergence. So, for instance, the CMA may be more attracted to an effects-type approach, which is potentially good news for economists, while the European Commission could continue with a more formalistic approach. It's also worth bearing in mind that France has historically been attracted to a more protectionist stance, where support is given to national champions, and indeed President Hollande has mentioned that competition law may need to change as a result of Brexit. And it is possible, therefore, that following the exit of the UK, France will be in a stronger position to influence that debate. However, I think that prospect remains low. So, in summary, we expect little to change in the short term, and companies should continue to ensure that they have robust competition compliance programs in place. If you trade in Europe, and I would include the UK in that definition, you will continue to be bound by competition law. And that will still be the case even if the UK does eventually exit the EU entirely. So I'll now hand over to Jonathan Rogers, who will talk about the potential impact of Brexit on financial services.
Thank you, Robert. I'm going to look at the single market for financial services, in particular in the light of the fact that during negotiations, access to the single market in financial services is likely to be a key factor. I want to start just by explaining what the current market looks like. We've got a series of single markets in the EU covering a variety of different sub-industries within financial services: banking, insurance and insurance mediation, brokerage, investment services of all types, payment services, e-money issuance, fund management and marketing of funds, as well as retail funds. In respect of all of these different activities, you're allowed to passport, and passporting is a two-way street, so UK businesses can passport into Europe and vice versa. Passporting can occur in two different ways. You can provide your services cross-border, maybe through occasional visits, websites and sort of electronic access. You could also go and set up a branch, an establishment in other EU member states and operate a business from there under the passport. The trick to it is that it's all based on home state licensing, so you only need to get one license in your home state, and that serves you throughout Europe without needing to duplicate. Those markets work on the basis of common rules, both as to business, how much capital those businesses need against a rainy day, and also how they're governed. And there's a variety of, if you like, secondary rules that support how they function, whether it's as to anti-money laundering, market abuse, or access to markets and exchanges. So that's the status quo. The challenge in negotiations is going to be to work out the extent to which the UK can access these markets. Obviously, if we stay in, there's no change, and that's a great result. It seems unlikely that we're going to walk away entirely. There's clearly going to be a negotiation. The question is what pressures will arise on those negotiations. First of all, looking at market rules. it's important to have convergence of rules across anyone participating in the markets to make sure they operate in a fair way and that there is a level playing field across the entirety of the market. Otherwise, some jurisdictions get an advantage. It seems unlikely we're going to be able to avoid complying with the rules. I know there's a sense as part of the Brexit process that we don't want to surrender any more sovereignty to EU legislation, but it seems unlikely that we'll be successful there if we want to access the markets. Secondly, participants have an interest in being consulted in the rules. Colleagues today have described, for example, the Norway approach as a way of accessing the markets, but they do surrender the ability to be consulted on and vote on legislation. Where we've got a large part of our economy based on financial services, where we are a leading, if not the leading consultant when it comes to regulatory change in financial services, we're going to surrender that lightly, I would have thought. There's also been mention that there are already third country rights that we could fall back on if we do have to exit the single markets. And indeed, I've heard reference to the fact we could look to WTO, World Trade Organization rules, as a way of access. Unfortunately, those rules are not subtle enough, are not engaged enough with different markets to cover financial services. They're just not a solution. So at the moment, there is no particular default that would serve us if we fell out entirely, and that will be a pressure on negotiation. There will also be pressures arising from the practicalities. In order to obtain a license in your selected member state, you need to have your key management, your capital, and your key resources in that home state. So if there was pressure or incentive now on businesses in the UK to move somewhere into Europe, this would mean moving that resource, which clearly could be expensive, very disruptive. If they wanted to retain a business in the UK as well, possibly business would be duplicating that capital and that resource. There's also the case that in the London market at least, there are a very deep range of secondary resources that are helpful to that business, whether it's data centres, exchanges, hardware, software, people, or professional support. And people won't want to leave that behind, and again, there's disruption there. One thing we might see is that businesses look to get licenses in other member states, and Ireland has been mentioned frequently in the last week with regard to UK businesses, and then outsource back into the UK some of their core operational and staff sort of heavy arrangements to minimise disruption. The key thing there will be to balance the need to have sufficient resource in that other member state to get the licence there, to be able to access the market, and not outsource too much back to the UK, which would be outside the EU. So an interesting dynamic there and one to watch. I think what we will see at the moment, the extent to which businesses might need to move into the EU is somewhat hypothetical. We just don't know yet. But as the position becomes clearer, if there is going to be large-scale disruption, that's clearly going to put a pressure on the negotiation process, which perhaps hasn't fully found its voice just yet. Moving on to some next steps in terms of timing. Obviously, we've got, as and when we trigger Article 50, 2 years to negotiate our exit. But assuming we do continue to access the single markets on some form of diluted or watered-down basis as a minimum, there will be a huge weight of law to negotiate and to work through as to how exactly that will change. That will not be an overnight job. Some European directives in and of themselves in this sector take anywhere up to 8 years to negotiate. But we'll be looking at the whole piece and how it works. So that's going to take time. It's also a convention in the financial services sector, at least, to allow transitional periods for businesses such that when the position is clear, they've then got a period of time to adjust, move their business, make their changes, so they're not unfairly penalised. An aspect of that is also that businesses are conventionally afforded grandfathering rights, such that if they have a licence in one jurisdiction, under one regime or one regulator, they can move on an automated and light touch basis over to an alternative regime. And it will be very interesting to see whether other European countries begin to offer grandfathering processes to make life easy for businesses. Not great for the UK, but good for the businesses. So taking into account timing, transitional and grandfathering, I think we're looking at a really, for me, a 5 to 8 year timetable afforded businesses who are heavily integrated into these markets to make their move and decide what they need to do and execute that. In terms of some things to think about, I would suggest that businesses set up a Brexit team to make sure that not everyone in the business is spending 20% of their month thinking about this, but just a few people are spending 40% of their time looking at it initially just to work out how it can impact you. Clearly, if you yourself are regulated, it's going to have a bigger impact potentially. You want to be looking at things like, well, do you passport across the single markets? Are any of your business lines under threat? Do you deal with businesses across Europe? If you're not regulated, you would want to ask yourself the question, well, do you use regulated services, banking, insurance, and how long would you need to find an alternate resource? In almost every case, I'm very confident you will find an alternative within the sort of timeframes I'm talking about. So I don't think there's any immediate need to panic there. I think another important thing is to think about your key income streams, business relationships, and your resources, as Chris has talked about earlier, and understand how they could be impacted, as well as keep an eye out for short-term economic impact. It's already been addressed. If foreign exchange, for example, could impact you heavily, that's something you might want to have a look at, talk to an experienced broker to look at what you could do to mitigate that risk. I'm now going to hand back to Paul just to conclude.
So I'm conscious that we've effectively run out of time, and a number of people have sent through questions. So the relevant speaker will reply directly to anybody who has questions. And on these slides, you will see the contact details of all of the speakers, so do feel free to contact any of us. So to wrap up, in terms of business strategy, I think it's very important to remember that the UK does have the largest talent pool in Europe. We are a very diverse cosmopolitan country. London has more universities in the global top 100 than any other city, and that doesn't even count Oxford and Cambridge. And the UK's business environment has always been the most competitive in Europe, and that, if anything, that is likely to remain to be increased as a result of our exit in relation to more or less any deal that we ultimately do. We have very low corporation tax, low social taxation, and various forms of tax relief in the system to help, particularly with innovation. We are very much still the innovation capital of Europe. Now, if you are concerned, even though nothing, of course, is going to change for at least 2 years, as a number of speakers have made absolutely clear, there is always the possibility of setting up some sort of top co or other structure which would potentially allow you to have an entity in one of the other Taylor Wessing jurisdictions in Europe. And we would be very happy to put you in touch with colleagues in Germany, the Netherlands, or France, being obvious places. But as you probably know, we also cover most of Central and Eastern Europe too. And we have a team of people who are looking very much at Brexit and the implications for all of our clients who would be happy to help. And needless to say, we are reviewing with a number of clients already their Brexit needs, whether it's reviewing different commercial contracts or their employment or immigration needs, and we'd be very happy to do that for anyone. As Phil has alluded to, this is a really good time with the lower pound and the lower euro to look at potential acquisitions in the UK and in continental Europe, if that's what you were thinking of doing anyway. Obviously, currency values fluctuate all the time, but at least for now, if there was any potential acquisition that you were, or any other project where you would be having to pay in pound sterling or in the euro, this is a good time to be thinking to bring that forward. In terms of legal strategy, this is just to summarise some of the points that the different speakers have said. Do look at your workforce from an immigration perspective. Think about obtaining permanent residency, or at least registering any non-UK but EU nationals, just in case we don't end up with freedom of movement. Do look at any services agreements in relation to cheapy issues, and make sure that the possibility is covered off that cheapy may not actually apply when that contract comes to an end. look at your commercial contracts more generally for the sort of issues that Chris and Andrew have been talking about. Check your IP, make sure you have a Brexit-related strategy for all of your different IP-related issues. And as I've already mentioned, do look to see whether it would make sense for you to have an alternative corporate structure to make sure that you have an entity that is in the ongoing EU, just in case the UK is no longer part of that. And then we've just set out a flyer for your UK General Counsel service, which is a fixed fee retainer service that we'd be very happy to speak to you about. Likewise, we'd be looking for clients who we are helping with Brexit needs. We're very happy to talk about fixed fee projects, scoping whatever legal requirements are relevant to your particular business. And so just to finish, you have the mugshots of the various speakers with contact details there. And we thank you very much. I hope you found this useful. And needless to say, feel free to contact any of us if you have any questions at all on any of the Brexit issues going forward. Thank you and have a good weekend.